Hi, my name's Adrian Galley. I'm the Vice Chair of the South African Guild of Actors. We've been in existence for 15 years now. One of the main drivers behind the creation of the South African Guild of Actors was, first of all, to create better regulated working environments for actors. The main reason behind that, as far as we're concerned, for the benefit of the whole industry, is that we want a large professional talent pool of well-trained actors who are dedicated to their craft, and the film industry can draw on that pool. Now, unless you make acting a viable, sustainable profession, you're not going to get that. A lot of people start off as actors and move on into selling houses, you name it. Influencers, yeah, some actors are influencers, but there's no substitute for an actor who's well skilled in the craft. So as SAGA, we realized that in order to fight for safer workspaces, better workspaces, rates of pay that are sustainable and so on, we had to start somewhere. The main place to start was, why are we not a union? Well, actors in this country are freelancers. They're classified as self-employed, independent contractors. So we're not covered by any of the labor laws. We can't form a union, which is regulated under labor law. We've got to start somewhere. We thought, well, let's create an organization called a guild that hopefully will be able to do some of the things that a union would do. Snag number one, collective bargaining, collective organization. As independent contractors, we are subject to the competition laws in South Africa. By trying to collectively negotiate any conditions in this industry, we can be wrapped over the knuckles, quite severely too, for price fixing and collusion, as if we were fixing the price of bread in the market. So be that as it may, I'll come back to that to tell you where we are right now. We started engaging with, first of all, the Department of Trade, Industry and Competition. At the time, it was the Department of Trade and Industry, who were busy with the copyright reform project. That has taken, well, we started engaging with that in 2013. It's now 2020, and the Copyright Amendment Bill and the Performance Protection Amendment Bill are sitting at the Constitutional Court. They're due to be heard shortly. It's been a long road to get there. Why we got involved with that is actors in South Africa don't have any rights, statutory rights to royalties, residual payments for work that's doing well out there in the marketplace. We thought the best place to get that is in statute and in the copyright and performance protection laws. So we spent a lot of time working on that. Then we decided to engage with the Department of Employment and Labor, who had published in 2019, December, just before COVID hit, their intention to deem freelancers in the film and entertainment industry as employees for certain aspects of the labor relations legislation in total. In our engagements with the Department of Employment and Labor, we were able to suggest to them that a mere deeming provision in the labor law would not really suit our industry that is built on flexibility. We need to be able to work with many different employers simultaneously and so on. And the way forward was eventually proposed to get a sectoral determination that would be included in the labor law, that would give actors and freelance crew members access to certain of the protections as appropriate in the labor law. The other sectoral determination that is in place in the film industry, you might be aware of, and that is the work that child actors do on set. You know, it's illegal to employ any person under the age of 18, I think 15 at a push, but children are effectively not allowed to be employed in South Africa unless in our industry. And in the film industry, you have Sectoral Determination 10, which sets out the terms under which children can be used on set, and it works very effectively. So we've done competition law, we've touched on competition law, we've looked at the labor legislation, the copyright legislation that will give actors the right to earn royalties in work that is performing well out there. The last one was the Competition Commission. SAGA was charged, along with the Personal Managers Association, PMA, with price fixing and collusion. And we had to stand up and defend ourselves at the Competition Commission, who were very sympathetic to our position. They realized that we're not corporates fixing the price of a slice of bread, but that we are actually trying to negotiate on behalf of individual performers who have no bargaining power in the marketplace. Yeah, the freedom of contract that is touted so often is all very good, but that only really works when you have a level playing field. And we know that take it or leave it is usually the option one is given. And we do need to have some kind of leverage. So we decided under Section 10 of the Competition Act, one can apply for exemption from some of those laws that prevent collective negotiation and so on. We applied, we invested in some pretty hefty legal support. We put in our application, and on the 31st of January, it was published in the Government Gazette. South African Guild of Actors and the Personal Managers Association have an exemption, conditional, for 5 years. We need to report back to the Commission on our activities in pursuit of our aim, which is to collectively bargain, to get people around a table, be they broadcasters, producers, crew, different, the editors, the writers, and so on. We've all got representative bodies, and to get round a table and talk about rates of pay, minimum contractual provisions, that sort of thing, which is all very well, and now we're allowed to go about that legally for the next 5 years until our sectoral determination is in place. Of course, we hit some headwinds. A certain organization that controls commercial production in this town have taken the whole decision to the competition tribunal. They don't believe we should have a level playing field. They want to call all the shots. So we look forward to seeing what happens in that regard. The same organization has been spreading the story that regulations in our industry will be unfavorable to attracting work from overseas. For many years, in fact, they sold us. One of the strengths we were touting out there was, I caused some blushes one meeting when I raised it, that come and film here, we still have slaves. They didn't take kindly to that. No need to use such emotive language. I thought, no, it's the truth. Anyway, we have now a position where the European Union has published a directive to any business that is either based in the European Union or has a substantial turnover in the European Union to have ethical production procedures in place throughout their supply chain. Of course, any company that has a substantial turnover in the EU includes all the Fortune 500 companies, for example, and their subsidiary brands, all of whom come to shoot their commercials here in Cape Town. Now, it's incumbent upon them to make sure that their supply chains are ethically clean. So it's environmental considerations, but it's also labor considerations. Do you treat workers with dignity and respect? And how well are you attending to human rights in the industry? So we've seen a bit of a drying up of commercials coming to shoot in Cape Town. There are a number of reasons for that, but I think the overlooked reason is that there's no regulation in South Africa of the labor force and in this industry. And while it might have been attractive to tout that as a selling point in the past, the grounds shift. and it's now no longer the case. Ethical production practices are required. And as SAGA, we believe that a stable labor force requires some regulation, and an attractive and sustainable career in any of the fields in this industry requires some stability, some regulation, some rules in place. And that all serves our mission to create a sustainable talent pool that the film industry can draw on well into the future.